one simple basic thing that you can do is put a compliant arbitration program in your onboarding package so that individuals, when they bring a case against you, it goes to an arbitration instead of litigation, state or federal court, and it can only be an individual case rather than a class case, which really multiplies the potential exposure.
You're listening to Home Care Hindsight, the podcast where we talk with home care leaders about the big mistakes they've made and the even bigger lessons they've learned along the way. I'm David Knack, head of sales here at Zingage, and I've built a career on the idea that we learn a whole lot more from our mistakes than from our successes, which is great because I've made a lot of mistakes. I've gotten to know some of the leaders in this industry who've built amazing businesses and are super well respected. So I thought it'd be fun, instead of asking them about the great things they've accomplished, to have them tell the story of one of the biggest mistakes that they've made and how that mistake changed their thinking and the way they run their business. All right, welcome back to another episode of Home Care Hindsight, brought to you by Zingage. I'm joined today by Angelo Spinola with Polsinelli. Angelo, welcome to the show.
Thank you for having me. Good to be here.
Well, Angelo, I think probably everybody knows you, but if somebody was not familiar with you, how would you introduce yourself?
I would say that I am the attorney for the home care industry. I work at the law firm Polsinelli, and we're a one-stop shop for all legal needs of home-based care. That's home health, home care, hospice, really anything post-acute. We do it.
How'd you wind up in this world?
I was a caregiver as a young lad going through college, not law school, but undergrad. So I worked with autistic gentlemen in a group home, quickly realized that I would be better serving from a legal perspective or any perspective other than as a caregiver, changing diapers and all of the things that go along with that. I got to spend a lot of time with caregivers during that period and see what it is that they do and the kind of passionate hearts that caregivers have, and always really had a fascination for the industry, wanted to help. Then I went to law school and I got involved in a big case, a large pay-per-visit case that ended up just sweeping the industry on the home health perspective. So I was the defense counsel for several of the big home health shops. Then I got involved in the personal care side when litigating the live-in and companionship exemptions back in 2013, and then just quickly realized that this is an industry that really needs somebody on the wall from a compliance perspective, highly regulated, lots and lots of issues, really challenging. I'm a labor guy, so very difficult industry to operate effectively because you're dealing with a remote workforce. They're paid different rates for different kinds of work. They live and work in the same place. There's just so many issues that there really wasn't much of a need for me to branch into any other industry. So it's been a passion of mine. I've been at it for 25 years now, and I absolutely love what I do.
You got here early, but obviously this is a place that is going to continue to grow. There's a lot of interest in home care these days, but I'm sure back when you got into the space, people were looking at you crazy. Like, what are you getting into this line of work for? There's a bunch of other kinds of law you could practice.
Yeah, there were really only a few in the beginning, and now there are others. And I switched firms about 5 years ago to really be full service. So I was at a boutique where all we did was labor and employment, and that's been a huge shot in the arm for me because I'm learning about all these other areas about, fraud and abuse and transactions and all the things that we're doing for our client base now. So it's been really fun. It's kind of like a second career.
Yeah. One of the big things that you oversaw was this companionship exemption case. As you think about the kind of big sweeping regulatory changes right now, are currently impacting personal care, that may impact personal care in the very near future, what are you seeing? And it could be something that's a blind spot for a lot of the listeners on this show.
Yeah, well, that's a big one. What you just identified is a big one, right? Thinking about the live-in and companionship exemption and the likely return of those exemptions, what impact that will have on state law. I think it's about 30 states that are going to be impacted one way or another, minimum wage and or overtime. What is going to happen as a result of that? I don't anticipate that we're going to see a big reduction in pay for caregivers, but I think the way that the composition of pay will be different, where the caregivers who are willing to work more hours instead of being artificially restricted on hours, capped at 40 hours, they'll be bonused. It might not be overtime. It might be a form of a bonus or something else, right? To really incentivize duration bonuses for those who are working longer periods of time, right? Really focused on retention and maximizing the number of hours that agencies can get with one caregiver, which is going to, blend in nicely with the issues we're having right now about the shortage of caregivers and having to artificially restrain them. So that's one big one. State law is changing so rapidly now. It used to be that federal law would change once in a while and state law would change every once in a while. You'd see minimum wages go up and things like that. Now we have all of these specialty issues, right? Specialty laws that we're seeing not only at a state level, but a city or municipality level and a county around, domestic worker bill of rights and all these things that are sometimes industry specific. Sometimes they impact everyone, but those laws are changing very rapidly, faster than we've ever seen. And we're not keeping up with it, right? The industry is not keeping up with those changes. And I think that's one that can catch folks off guard.
I was on a call, and the smart thing to do as a salesperson is to not pretend like you know all the stuff. And so people bring things up, and like you feel dumb because someone will be like, "Oh yeah, this whole sick leave, something, 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 something," and it was something weird. And I was like, I don't think anything changed like on a federal level. I don't know anything about state law, and so maybe something changed there. And I was like, "Hey, just a quick question. You said something about something, something sick leave. Can you tell me a little bit more about that?" And I go, "Oh yeah, it's like a municipality-level requirement." And I was like, well, I'm glad I didn't pretend to be like the guy who is an expert at like your municipality law. In Arkansas, we have a municipality that legalized recreational marijuana called Eureka Springs. And you go there and you're like, yeah, they did. Because the rest of the state's medical. And it's just these weird things that municipalities will do. And the folks in that space have to figure out how to keep up. But it's got to be challenging from your point of view, staying abreast of all of those changes at federal, state, local level, so that you're able to serve the folks in those markets. How do you guys approach that?
Yeah, we literally have a team. We have a program here called POSH, Polsinelli Online Solutions for Home Care. And we have a team of lawyers that's dedicated to providing resources on, guidance on the forms that you need to use and documents and things like that. So they have legal trackers that they're following. They know what the proposed laws are. They know when those laws are set to come into effect, when they sunset. It's a strong team, and everybody's sort of responsible for different regions. And you think about it, I think you hit the nail on the head. If you're a national provider or a multi-state provider, and now you don't have to deal with just federal law and state law, but also all these municipalities that are constantly changing, how do you keep up with it and operate your business, right? That's our job. Our job is to track and follow and comply with the law, or help our providers to comply with the law. But that isn't the job of a provider, right? It's something that you have to do, but the job is to provide quality care and operate an efficient and powerful, business. So how do you do that on top of everything else? It's not an easy task.
One thing, and I want to get your perspective on this, is we're seeing more and more adoption of AI solutions in home care for obvious reasons. There's so much efficiency gain. There's so many problems in home care that the solution has been, we got to hire 40 more people to solve this EVV compliance problem or to solve this recruiting problem or whatever the case may be. And so now AI implemented the right way has a real promise of bringing some efficiencies into this market that previously were just kind of a brute force solution. There's an obvious regulatory looming thing on the horizon. What's kind of your perspective on the exciting opportunity that AI presents in this space? And obviously there's a ton of folks, us included, who are bringing solutions to market, balanced alongside state by state kind of regulatory stuff that could come to bear at any time.
Yeah, well, that's been a significant development as well in the area. That's sort of the history there is Biden was going to heavily regulate AI. That was his intention. We were going to see a European style oversight and, and specific to healthcare as well. There was an EO executive order specifically designed to analyze AI as it pertains to healthcare, right? With a committee and all these things. Trump did away with that. And then the states started implementing all their own laws and creating, just like we were talking about, across the spectrum, these hodgepodge of different laws and notices and consents and these things that you had to do. Trump very recently, I think it was in December, the end of December, issued another executive order that effectively created a legislative task force. And their job is to litigate against states that are being overbearing in their AI laws and create some standardization around some of the basics like child safety, data security, right? Things that we all are in agreement that we need to make sure that our AI tools are compliant with. And I think that's going to, and the goal is to create basically a super highway to be the first and the fastest to the solutions that work. And I think that's going to be a major boon for companies like yours, right? That have AI solutions that will really allow, you still have to think about, what notice do you have to have for a client, for example, if you have an ambient system in the house that's kind of capturing data and things like that. But it's much more minimalistic than I think what we were going to see. And that really paves the way from a regulatory perspective to allow for these systems to be put in place. Now, I would say that I think we are a little bit behind as an industry in the adoption of AI. I think the tools are there and they continue to get better. There's a lot of, with our client base, a lot of hesitancy of, well, how do we implement this? And is it really going to work? And is it going to cut our hours? Is it going to be a replacement for caregivers? I don't ever see that happening. This is a hands-on business. I think that AI in other sectors is really going to help with some of the caregiver shortage that we have, because this is the kind of business that it's a local business and it's a hands-on business and you need to have people, but the ability to have tools and resources to make us more efficient, especially with what's going on with, the cost of care increasing, rates being cut all over the place. We have to be more efficient. We've got to be better in our scheduling, right? In our how we coordinate travel time, right? And where people are going in the home health space. Let's make sure that we're going to, taking the right drive here, and that we've got somebody that can look at this and figure out what, we've got to go see 4 patients today. What order should we go see them in? How do we make a caregiver, optimize their schedule where they'll do more work with us and we're giving them the opportunities they really want to see. So, those tools are there, and I think it's up to the provider to implement them and, really learn how to utilize those to make their business more effective.
Yeah, I say this frequently, but Anna Karenina, Leo Tolstoy, the first line is, every happy family is just alike. Every unhappy family is, unhappy in their own way. And there's a corollary to home care, which is every home care agency is dysfunctional in its own way. The kind of operational requirements that one agency has is going to be different from another. When you're doing 2 to 5 million revenue, there's a bunch of headaches that exist there. When you're doing 20 to 50 or 3 or 400 million in revenue, there's a different type of problem. And so one of the things that I think is going to be so important from an implementation perspective is how do we make sure that these are not one size fits all kind of custom GPTs across the board, but that they're really like tailored to the nuances and operational complexity of this provider in this market with these types of caregivers and these payer sources and these acuity levels of clients, because the devil's in the details. And so that's, I think one of the biggest challenges from an operational perspective is how to not just have something that's a blank slate, but instead have something that can be really configured and tailored to what you're doing.
Yeah. One of the best pieces of advice I heard from anyone was somebody who, when evaluating AI systems, basically said, identify what your problem is. What, for you specifically as an organization, is an area where you struggle, where are you having a problem with retention? Are you having a problem with scheduling, right? And issues there. Where's your issue? And then go find the solution for that issue, right? Because there's a lot of shiny toys out there that look like they'd be great, but if it's not a problem you're experiencing, then you're probably not going to actually use it, right? Because there's the tool, and then there's actual implementation and use of the tool, and it's got to solve a problem for you to really be using it.
100%. And being on the sales side of those conversations, the scariest thing for me is somebody who's really, really excited about AI in general, but doesn't have the specific applications. Because it's like, look, I guess I could sell this person something, but are they going to use it? Are they going to get value from it? And if they don't, like, it may not be anything wrong with the solution. It could just be wrong fit. And then I've got to deal with the kind of brand consequences of someone out there who had a bad experience. And so I know there's a lot of people who will sell the thing, but that's scary for me as somebody who comes in with aspirations of adopting AI, but no real use case for the problems that it's going to solve. Moving ahead, what's the biggest mistake? I mean, I'm sure you've seen a ton of horror stories from your time in the space, but what's the biggest mistake that you've seen an agency make in your career? And what can owners learn from that?
Yeah, well, if I'll give you a couple of specific examples of some things that I have seen. I've seen a lot, as you can imagine. I will exclude the names to protect the innocent or the guilty, as it may be. But in general, I think one of the things that you see a lot is sort of this Me Too mentality that, well, like everybody's doing this, so what's the problem? Or, hey, this has never been a problem. We've never had this problem, right? What you're forecasting as an issue has never been a problem for us. So why should we be worried about it? And inevitably, from a compliance standpoint, you're always, if you are a business of any scale, right, you're always going to deal with this, and it may be, I look at it like flood insurance, right? You might, if you live in a flood zone, and believe me, the home care industry is a flood zone, right? There are government investigations. There are DOL investigations. There are lawsuits galore, right? All sorts of issues that are, always going on. So it's a flood zone. And if you're living in a flood zone, you need flood insurance. And the argument isn't, well, I haven't seen it flood yet, right? These are often catastrophic issues that come up, right? And they only need to come up one time for it to really level a business. And that's something that, as these businesses scale, right, it always is the same. You look at the same formula, right? Clients come to me, one of a couple of ways. They're small business and they start with either no lawyer at all, like LegalZoom, or, a local lawyer that organizes their business, but doesn't really understand the industry or the nuances of regulation, healthcare regulation. And eventually they grow larger and larger and larger, which makes them more and more of a target. And either they elect, they hire I've got a new client now that just hired a compliance officer who's been there and done that. And is like, all right, we have some real issues. I've looked under the hood. We've got real issues. We need help. That's awesome, because now you can address things on a much different scale. You're not responding to anything. You're not dealing with litigation or investigations, right, which are far more costly than just dealing with the problems. But what we are typically doing then is stripping down the business and rebuilding it the right way. So the longer you wait to do that, right, the more expensive it is, right? So doing that early, and that would be what I would recommend, is to focus on compliance early. So that's one way, the proactive way. The other way is a reactive way where, geez, we've got this lawsuit and nobody saw it coming. Nobody budgeted for it. Half the time, probably more than half the time, the provider didn't even realize it was an issue or a problem or something that could get them in trouble, because, like we were saying before, they've been focusing on operations. They've been scaling and growing. And without even realizing it, man, we're now a target and we've got something of value that other people are going to look to get a piece of, right? And then the third way, and this one is, when I say that it's inevitable, you're going to deal with compliance. If you ever are planning to sell your business, let's say that somehow you never had an issue, right? And now you've scaled your business and let's call it a $10 million top revenue business, something like that. And now you've got, another strategic provider that's about to buy you. They're going to conduct diligence and they're going to uncover all the things that we would, right, have done it from the beginning, right? in addressing compliance. And that's going to change the enterprise value, that there's going to be escrows and holdbacks where, man, I don't get all of my equity out of this business because of this potential risk, this tail of possible liability that, it's a 3-year statute of limitations. So I get paid out after 3 years instead of immediately. So one way or another, you're constantly going to be dealing with compliance, and hopefully it's not in a reactive way. It's a proactive way. That's what I always encourage people to do. And that's a lot of the reason that I do what I do and speak as much as I do, is to try to get to that provider before the enemy, right? Before someone else gets to them, right? And, when that happens, it's not just whatever the liability is, right? The back wages or whatever it is, it's penalties, it's attorney's fees, it's, it's accelerated so much. It's time, distraction. So it's just such a different animal when you're dealing with that. So that's overall what I would say is focus on compliance early, and don't look at what your neighbors do as an example of what you should do. I was mentioning that pay-per visit case. That's a perfect example, right? So what that was how I got into the industry in the first place. And it's exempt clinicians. They were professionally exempt, and they were being paid flat fees, right? Pay-per visit. So for each visit, a flat fee, but that was also mixed with hourly pay for in-services and case conferences, which is a no-no under the fee basis regulations. Nobody knew about the fee basis regulations. One firm in DC decided, ooh, this is a good case. These folks are making $90,000, $100,000, or working 50, 60 hours a week, and they're not paid any overtime. And we think that this hybrid pay practice makes them, puts them at risk. So I handled the case, and everybody was paying this way. So all the major home health companies, and in many ways, in many instances, some of them still are. And this firm had a field day just going after, and that's how plaintiffs' lawyers work, right? It's not an issue until it's an issue, and then it's an issue for everybody, because they take the same complaint, change the names, right? And, and bring that lawsuit against every major provider. So that's how, the case I had was about a $300 million potential exposure case, $300 million simply by, paying in services and case conferences a certain way. I mean, a huge issue. Now, this is a national provider, a big multi-million-dollar provider, right? But massive case. And everybody was looking to each other to come up with their pay structure from an operational perspective. And in fact, even the consultants were saying, pay this way. Pay this way is better than paying salary or salary plus. This is a good way of paying because it moderates, how much income you're getting, is what you're paying the individual. So it made perfect sense from an operational standpoint, but it just wasn't compliant. That was the one problem.
Aligned incentives for everybody except for the regulatory bodies.
Yeah, so you see things like that all the time. I would say but lately, and I think this is timely because there are so many government investigations right now, fraud investigations. We're seeing the VA is cutting rates and cutting contracts. We're seeing it with Medicaid waiver programs. We're seeing it all across the board, with the DOJ being very, very active. They had, all-time record recoveries, both in the criminal and civil divisions in this last year, in 2025. So we're going to see that continue. But I got a call recently. It was not a client, but they had gotten our name, and it was a husband and wife team as a Russian couple. And they called and, explained their issue. And basically what had happened was the FBI came to their establishment and collected a bunch of documents, collected recordings, all sorts of information, cell phones, cell phones and computers. And all this happened. They called their local attorney, and the local attorney said that they would be there in a few hours. By that time, the FBI, and there were several FBI agents. It was like 5 or 6 FBI agents talking to everyone. And this couple, right, what they were doing, this was a criminal investigation, which is, criminal investigation. These folks were thinking that they didn't know about the issue, right, which was an overbilling kind of issue, right, or billing for services that weren't performed. that they say their administrator was solely responsible for, and they weren't aware, not understanding that the administrator binds them and that they should have never given anything to the FBI that they didn't keep copies of. They didn't have copies of anything. And, one of our fraud and abuse attorneys was on the phone with them, and she's, we got off the phone and she said, those two are going to jail. They're going to go to jail. They had no idea what the deal was, like how, significant the issue was, but they weren't prepared. They didn't have any, they weren't looking, at their own operations to see, are we doing this appropriately? Are we self-checking? Right. And then they responded, and so did their attorney, the exact wrong way to one of these investigations. You cooperate, but you don't provide anything that you're not supposed to or have to provide pursuant to a subpoena. And if you do, you keep a copy of everything. Right. So, that was probably 6 months ago or so, and they're probably not in jail yet, but they're going to jail, and they're going to go to jail for a long time. And sad to see. It's sad to see that, that's a rare, normally these are more civil in nature than criminal. But I have to say, because of the criminal element of that's probably the biggest mistake I've seen lately.
Hey, that's a big one. Just out of curiosity, what's the biggest number that you've seen impact enterprise valuation when somebody goes to sell because of one of these like compliance risks that you guys are seeing? I know you're not on the M&A side of things, but you're close to it.
I do a lot of M&A work on the labor diligence piece of it, and I like to put together buyer and seller a lot. That's a real fun. It's a passion of mine because it's somebody's baby, right? That they've grown up, and it's really fun to see a founder sell their business and do it effectively. So I love that side. That's one of the areas I was talking about that we get to do now that I didn't get to do before. It's really fun. But, I will say this, that it is really, really important, the counsel that you have on a transaction, particularly a larger transaction. Sometimes you see owners try to do some of these things themselves. Maybe they don't want to work with a banker. They want to do things themselves, and they just get run over, especially when it's a private equity backed buyer. And what will happen a lot of times with the valuations and with the risk assessments is you can take let's say it's a California provider. You're going to find problems in California, and that means penalties, and there's these claims that sort of all attach to each other. Well, if you didn't pay overtime appropriately or regular rate or provide rest breaks, then that changes your pay stub. So your pay stub's not accurate, and blah, 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 blah. And then there's all these penalties. So you can take a claim that maybe is a $10,000 claim and easily make it into $1 million claim with penalties and, class members. And, so you see these assessments that sometimes the buyer, well, look, there's, $40 million of potential exposure here. And as a litigator, we're not paying $40 million. We might pay $1 million, or $800,000 to make it go away. But, you can't extrapolate in that way, but you often see things like that. So what I would call funny money, monopoly money, say, we're not going to make you hold all 40 million, but we need to hold 10 million, or we're going to have to drop our price down by 2, and you're getting a hell of a deal. Right. So you got to watch that, but it doesn't take much. I mean, you can, and like I said, as soon as you find something, and it's really hard, I think, from a compliance perspective, not to find something if you don't know like the mechanics of litigation and how you would whittle down that number. You're going to be looking at millions or hundreds of thousands of dollars of potential exposure, which then oftentimes is dealt with through escrow. We'll hold some of that money, and then every year, if it's 300,000 over 3 years, and you pay out 100,000 in year 1, 100,000 year 2, and then we're done with it. But a lot of times, especially in a seller's market, if it's a good, healthy business, there's not that many businesses that are plus 10 million in revenue that are willing to sell. So that's a seller's market, and if a buyer gives you a hard time, just go to someone else.
Yeah. Makes perfect sense. Okay. Blind spots in the business. What are the biggest things you see that, and I think we may have already touched on some of this, but anything else that are big blind spots from a risk or regulatory perspective that just, is under the rug, just out of sight, out of mind?
I think the fraud and abuse stuff, right? Inconsistent EVV records, upcoding, things like that, where a lot of businesses don't have internal compliance processes, right, to audit their own records. So they're surprised when they get an investigation. The other thing is that sometimes providers think that for you to be investigated by the government, you have to have a government payer. And that is not like you have to be a Medicaid waiver shop, something like that. But that isn't always the case. Like there are anti-kickback laws that will apply at a state level across all payers, including private pay. There's a lot, I think, in the personal care space around HIPAA compliance and failing to be HIPAA compliant, thinking that HIPAA, it doesn't apply, which it most often generally does apply to a private duty organization. And I think that surprises some folks. And then there are what I call gotcha claims, sort of going back to that theme of new law, right? Now, if it's new law that is a strict liability law. So let's take, for example, wage transparency. That's a common one. So, okay, you now have to, in a so-and-so state or so-and-so city, you have to put the rate of pay, the range of pay for a position on a job posting. And I've hired, some recruiter to do all my job postings. I'm looking for these positions. The recruiter isn't following that law. I'm thinking it's a recruiter's responsibility. I'm not necessarily following the law. It's a strict liability law, meaning you either did it right or you didn't. So per application, per job posting, right, each applicant creates a fee. Maybe that's $2,000, $3,000 a pop over the course of a couple of years or a year, not doing it right. And you see even the big, like Amazons of the world and, big companies sometimes getting hammered with these kind of cases. So what happens is the plaintiff's lawyer just finds somebody, a paralegal to go searching Monster and Indeed and looking, are there any job postings that don't have these? Okay, well, here's one. Let's get somebody to apply. And now we have a class action lawsuit. So those kind of gotcha cases, and there's a bunch of them around biometrics, around, wage theft notices, having to have employment agreements. Now, where we really see issues is when the law is industry specific. So a domestic worker bill of rights, example, Philadelphia. In Philadelphia, if you have caregivers in Philadelphia, they have to have an employment agreement, right? And not everybody in Philadelphia knows that because there's not a ton of coverage. We cover it because we're the home care law firm, right? But you don't see a lot of news about it like you would paid sick leave that applies across every industry, right? So you're going to see lots of law firms and lots of publications around that, and hopefully the provider gets notice of, oh, I need to look at this. But unless you're involved in associations or you're getting client alerts or, really plugged into the industry, the home care industry, that might escape you. The healthcare minimum wages that we see in like New York or California, right? Of, oh, wait, I have to pay something different than everyone else, or show up pay or spread of hours. There's all sorts of laws that are specific to the industry that many in the industry don't know about. And when there's that private right of action, when, it's not just the government that can come after you, but individuals, California and PAGA claims, all of a sudden now you get this scourge of lawsuits that just spreads across the industry.
As we kind of wind down here, I know we've talked about a lot of various mistakes. I want to kind of shift gears for this next question and kind of ask, many providers are in this bucket where having a full-time, chief legal officer, chief compliance officer is not on the table. They're putting, every bit of profit, gross profit in the business into making the operations run better. They're not thinking about the regulatory risk. They're not thinking about the compliance risks. What are the kinds of things that can get them in the right rooms, in the right conversations, aware of the stuff that's changing? Like, what are the little things that they could do to kind of stack the deck in their favor?
One is to be informed, right? To stay informed. And there's lots of free ways of doing that. Things like your podcast, right? We do a alerts for all of our clients and the folks that we know, where we send out, if there's some major news, we send that out. There's industry webinars, like I said, plugging in with the associations and hearing, particularly the local associations that really understand what's going on from a rate perspective. So there's the free stuff. We have a program, that Posh program, which we try to make it super easy. It's basically a subscription cost share that many providers utilize to stay apprised of what are the laws and what are the documents and materials that I need to use in my state. So there's lots of ways of doing it. One tidbit that I would say, and this actually is another war story, because it's one of the biggest issues I've seen, but it's also an issue that comes up time and time again, is not having an arbitration program. Like, that's one simple, basic thing that you can do, is put a compliant arbitration program in your onboarding package, so that individuals, when they bring a case against you, it goes to an arbitration instead of litigation, state or federal court, and it can only be an individual case rather than a class case, which really multiplies the potential exposure. It is the number one defense tool, other than being compliant, right, that you can put into place. And so many companies haven't done it. It's such an easy thing to do, or they haven't done it the right way. They try to do it in a handbook, or it's the wrong kind of agreement that isn't going to work. You could do this in every state. And, to give you the story, this one's pretty wild. This was a large company. They implemented arbitration. So they did do it, right? And they did it after that big class action I was telling you about, the one that had 300 million in potential exposure. That was a national. So now we have a California class around pay-per-visit again, right? The same issue, which pay-per-visit really can't be utilized effectively in California, but unfortunately they were. And they had all the clinicians, at least they thought all the clinicians, sign arbitration. They had lots of clinicians, David, all across the state. So they couldn't get everyone in meetings to, have a signed document. So we created a new version of the arbitration agreement that could be emailed, and you're supposed to get notice, because notice is the requirement, the confirmation I've received this. Now, our plaintiff who brought the lawsuit, she got the email with an arbitration agreement, but it was the wrong one. It was the one that required signature. So this was a basic human resources mistake, just a HR mistake. That was a $19 million mistake. $19 million, because this individual, we tried to compel arbitration anyway and say that this should apply. And the judge said, well, there's a signature on it and it wasn't signed, so it's not a executed agreement. So she was able to bring a class case. That case would have probably settled for $10,000 or $15,000. Instead, it ended up being a $19 million settlement. So that was a pretty big mistake too. So, and if you're a smaller business with 100 caregivers, you're not going to have a $19 million case, but 100 caregivers can certainly net $1 million plus. And an individual caregiver cannot do that. And this isn't a way of avoiding compliance. You want to be as compliant as possible, but you have to understand that when an attorney is suing you, they're not suing you always because they think that you're a terrible company or you're completely non-compliant. They know that you're likely to settle that lawsuit. And if they can bring it as a class action, it's far more valuable to them and costly to you. So take that chip away from them and make it a one-on-one fight, in which case you're going to have a lot more success. And if you do settle, it'll be for a lot lower dollar amount. And, that's just an easy fix, right, to a lot of the problems that we see in the industry.
That's some good free legal advice. Implement arbitration.
Got to do it.
Angelo, I appreciate that you're a lawyer who is not answering all of my questions with "it depends." Thanks for that.
Yeah.
That's also a very black and white, non-it depends kind of thing. If you're in home care, implement arbitration.
That's right.
Very good.
If you got 50 or more employees, to me, it's a must-have.
Yeah.
Flood insurance.
Well, thanks so much for making the time to come on today. Before we wrap up, what do you want to plug as we kind of round this thing up?
Listen, I will plug our firm. That's another thing that I see a lot of is, I mentioned this earlier, providers working with perfectly good lawyers, but not industry specific lawyers. And it makes a big difference. And, our firm is really designed for the home-based care provider. So would love to have the opportunity. And we do all sorts of like the POSH program, right? For smaller businesses that maybe don't want to pay my hourly rate. I understand that, right? But let's work on compliance. Let's help you take some of the steps that you need to take. And you don't have to do everything all at once, right? But there are things that you can do like that arbitration program that are pretty easy, a step in the right direction. And by the time you're ready to sell, or in the event of a rainy day coming and one of these investigations, you'll be ready for it. You'll give me the ammunition I need to defend you well. So would love to work with anybody listening that is in this industry.
I love the POSH program because it's a way to cost share the hourly rate. Lawyers are not cheap. And so for smaller orgs, I think there's probably an assumption of, well, I've got to get with the local guy who is more affordable, more within my budget. But you guys have worked to develop a solution that's within, many more types of businesses' budgets than having, Angelo specifically on retainer.
That's right.
Well, very good. Angelo, thanks so much for making the time. This is a ton of fun.
I appreciate it.
On behalf of the team here at Zingage, thanks for listening to the show. We'll be back next week with another episode, so be sure to subscribe wherever you listen to podcasts on Spotify or Apple or YouTube. Leave us a rating while you're there. It helps other people find the show. If you have comments on the show, drop me a line, david@zingage.com. Would love to hear from you, chat with you there.